I'm thinking,
Are you? Okay, good.
thinking.
Glad somebody is.
Yeah.
You gotta think
Good.
today, you know
This is
why?
Monday.
Yeah, but today's Pi Day.
Is it really?
Yeah, 314, the ratio of the diameter to
Oh, I
the
thought it was
circumference of a circle.
Like
No, Pi
banana
Day,
cream.
3.14 onto infinity, you know, pi, pi. Yeah, it's a very special, very
It's been
special.
showing up on the
Wow,
weather.
Very special day
That's a
today.
special
And I
day.
go,
Right.
what is pi? Pi Monday.
Okay.
What is pi?
Multiply the diameter by pi to get the circumference of a circle.
Isn't
It's a
it-
constant ratio.
Point something something something.
3.14. That's why March
That's what I thought it
14
was.
is Pi Day. Yeah.
Three.
Yeah.
Is it
3.14.
3.14?
3.14. 3.14, and then ad infinitum, as we say in Latin.
Ask Matt Rosenberg's son. He knows it.
Because
He gave a really nice speech in front of council last year or 2 years ago, and pi was part of it.
I think it was
Really?
23
It was
years ago.
the oratorical contest. He won. It was one of the winners.
So anyway, happy Pi Day. Okay? And for those of you that don't really care about math, just go have apple pie, cherry pie, whatever pie you want.
Banana cream.
There you go. Okay? Life is good. So,
So what's happening, Laura? Your show.
Oh, that's right. So we thought we'd talk about landlord damages, things like that.
yeah, and the only reason is I have a trial going this afternoon, relatively small, and two issues this afternoon in the trial. One, the sanctions against the lawyer and the party on the other side for raising a frivolous defense, which fortunately courts are granting more and more against parties and their attorneys for filing frivolous lawsuits and for filing frivolous defenses. So that's the first order of business at the trial this afternoon. And then we'll go into a trial of damages alleged to have been done by the tenant, and also the issue of unpaid rent. But it's the damages issue that will be front and center this afternoon. And one of the issues that, one of the defenses that they raised, this is earlier on, was that, well, you can't sue for damages more than 45 days after the tenant has left the property, and that has nothing to do with the ability to go after damages. That has to do with going after the security deposit. So
Well, the security deposit's 30 days anyways.
actually filing lawsuit within 45 days, I think, after the tenant
Yeah, but if
has
you have a
left.
security deposit, I mean,
I'd have to look at the statute, but you've got to, the
so you
tenant
have
has
4
to get-
days
tenant-
after you move out to notify the landlord of your new.
Landlord's
address.
got 7 days, I think, to notify of damages.
No,
Can't remember the
30.
time limit. 30?
30. And if there are damages and you send a
If the
check,
tenant contests it,
that's-
if
then
the
they-
tenant has so many days in which to contest, but my recollection is it's 45 days to file a lawsuit. But there
but
are all
the
those
tenant's
timelines.
filing the lawsuit, not the landlord.
No, the landlord's filing a lawsuit, because if the tenant objects to the landlord keeping the deposit, then the
Okay.
landlord must file a lawsuit.
Oh,
My recollection is 45 days on that one. But that has nothing to do with this particular trial, because we're not going after a security deposit, because unfortunately, the landlord didn't bother to get a security deposit. More importantly, the landlord didn't even have a written lease, it was just an oral lease. So,
good thing you're a good lawyer.
That's tough to defend, isn't it?
to defend on, for me as the landlord's attorney, or for
You
them
didn't even
as
have a lease?
in Michigan, you can have an oral lease of
Verbal?
a year or less. Yeah,
Okay.
an oral lease of a year or less is enforceable. The attempt of either party to enforce a lease longer than a year would be barred by the statute of frauds. It has to, a written instrument for, a lease in excess of 1 year has to be in writing, signed by the landlord and tenant in order to be enforceable. But you can have month to month. There are many landlords. I mean, if you get back to the issue of whether or not to have a written lease, I always recommend to my landlord clients have a written lease. Same thing from the tenant. I don't represent that many tenants other than commercial tenants, and they all have written leases there.
I just can't imagine anybody that wouldn't.
Well, I do have a case going in northern Michigan where I represent a landlord on a commercial building, and before the lease was signed, the landlord let this particular tenant into the property to make improvements. Well, the tenant went ahead and started making improvements, but then started moving in materials that are considered hazardous substances for use in the tenant's business, all before a lease was in place. Tenants started doing improvements without building permits. They got the building department out there, but what happened was, to make a long story short, without the written lease in place, this tenant, now having been lawfully put into possession, you can't simply call the police and have the police evict the tenant. You have to go through the eviction process. And that was a mistake by a commercial
So
landlord.
does the
who
landlord
wasn't-
not want him in there?
No, they haven't paid any rent. They're violating the construction code by making improvements without permits. They've moved hazardous substances onto the property. I mean, you talk about a nightmare from a landlord's perspective. This is one of those nightmares. So now we're having to, so we sent the demand letter, sent the 7-day notice to quit on this particular one because of the hazardous substances. But otherwise, we'd have to do a 30-day notice, because once they're lawfully in possession, now you have to go through the court process to evict them. Different from the squatters in Detroit. Those, they're not lawfully put into possession, so you can actually call the police and have the police oust them from the property. But squatter's different from someone who is lawfully in possession. Look, I've done a couple of cases where someone who owned and lived in a property, or even was a tenant in a property, let somebody move in as a favor into the property because the person didn't have a place to live, whatever it is. That person moved in without signing a lease, without doing anything. Now, the person who let the other person into the premises can't simply, you ask them to leave, they say, no, I'm not gonna leave, I don't have a place to go. They can't call the cops to
They
boot
can't
them
kick 'em
out.
out?
No, they gotta go through the court process to evict them. Gotta give them a 30-day notice and go through the court process. I've been through that one a couple of times too.
Well, if I've got a tenant that's on the lease and they let somebody move in, don't I have to evict that person too?
I'm not talking about the landlord trying to evict them, I'm talking about the tenant. Let's suppose you rented a property and you've got a girlfriend
Oh, right,
who
okay.
says, oh, I need a place to live, Lauren. So you say, fine, come stay in my bedroom, my spare bedroom, and you let her move in. Now you want her out, you gotta go through the eviction
So
process.
the tenant has to do that.
Yeah,
right?
yeah, in that case, it's the tenant who wants the person out.
Oh, but as a landlord, if my tenant lets someone move in
Without signing a lease.
without signing a lease,
And that person has to qualify.
and I want that person out as a landlord, I have to evict that person, or is that a squatter?
No, you can, that's not a squatter. They were put lawfully in possession by virtue of the fact that the tenant is, the tenant you signed a lease with is lawfully in possession. They can have their invitees, or their licensees enter onto the premises, even though it violates the lease. Now what you have to do is you have to start your action against the tenant who signed the lease, and the complaint says, Jane Doe and all other occupants. That's why you put that on the 7-day notice and on the complaint. Jane Doe and all other occupants. Anybody else who happens to be there who was let into possession by the tenant, even though they.
Gots to have a lease.
Yeah, you gotta have a written lease.
I mean, it's a.
Yeah. And there are plenty of landlords who say, I don't want a year lease, I want a month-to-month lease, so that I can evict the tenant on a 30-day notice if it is a, quote, bad tenant, end quote. By bad tenant, I want to make very clear here that you can't use the device of a 30-day or month-to-month lease to be able to evict somebody on a basis which is prohibited by law, whether it's a retaliatory eviction, where the tenant reports the landlord to the building department because they're building code violations, and so the landlord kicks them out on a 30-day notice, not because they want them out as a result of the 30-day notice, but because they want to retaliate against the tenant for reporting the violation. Or the landlord is discriminating against the tenant on one of the classifications which is protected under our civil rights legislation, whether it's disability, race, creed, or religion, national origin, that sort of thing. So, I mean, there's a huge body of law that exists with respect to landlords and tenants.
We've had our fair share.
Yeah, but the trial.
Although we've been pretty, I shouldn't say that, our tenants have been pretty good.
We've over the years we've learned.
Yeah.
Yeah, I mean,
So you can't just evict.
no, you can't evict for an improper, illegal reason. But if you have a month-to-month tenancy and you've got a tenant that's creating a mess in the place, but
Leaves
not
garbage
necessarily.
outside.
Well, that you can terminate a lease on a 7-day notice because they're creating a health
Health
hazard, a continuing and immediate health hazard, or if they're doing drugs, selling drugs, any of that sort of thing, I can get them out in a big hurry. But if you just have a tenant, maybe it's a habitually late paying tenant. I'm just tired of sending a 7-day notice to quit for non-payment of rent. I'm tired of going through this exercise with you, the tenant, every month, so I'm just gonna terminate it on a 30-day notice. That's perfectly acceptable. If you just have a bad tenant that's not, maybe not following the rules, terminate on a 30-day notice, not because they, not as a result of a violation of the rules or regulations, but you're just tired of having to go time after time after time. They're annoying other tenants. They're violating the rule against smoking in the premises, that sort of stuff.
So if I want an access to my tenant's property because I have a city inspection or we just need to do something to the property, can I just go in there?
No, you have to give the tenant reasonable notice, unless it's an emergency. But if it's city inspection, you need to go in and make a repair, which is on a non-emergency basis. You gotta give the tenant reasonable notice. Most written leases provide for reasonable notice. 24 hours would be reasonable, the day before.
Can you give them a window? Like, we'll be there during this week, off and on, between 8 and 4 p.m., 8 a.m. and 4 p.m., because we don't have any repairs we might have to make. And we might have different,
Yeah,
our notice says we'll knock, wait, if you're there, you answer, if not, we'll enter and leave a business card so you know we were there.
Yeah, and again, it's got to be exercised on a reasonable basis. Let's suppose you've got a repair that needs to be done, plumbing, and it's going to take a series of days because you've got to come in, you got to take a look at it, figure out what's wrong, order the piece or pieces in order to repair it. It's not necessarily a 30-minute or a 1-hour job. Then what you do is you coordinate with the tenant. If the tenant's uncooperative, you may actually end up having to go to court to get an order to go in there, but your written lease should provide for the ability of the landlord to go in upon reasonable notice to the tenant to make the non-emergency repairs.
So you can't go in and just look around?
No, absolutely not.
No?
Absolutely not.
If you suspect illegal activity?
I'd want to have some sort of probable cause as to what that illegal activity was. Give me an example. Drug use?
If you smelled something funny?
Like incense, you mean? Yeah, like marijuana,
Use your
that sort of thing.
imagination.
Yeah. If I have probable cause, if I have reasonable cause to believe,
You can go right in?
No, I can't go in. I'd give the tenant notice. No, I'm not going to go. I'm not the police. I'm not busting in on illegal activity. If I think that there is drug use going on, I'd call the cops, have the cops do the investigation. But as a landlord, my tenant is entitled to rights of privacy. That's their home, that's their castle. I can't go in and simply invade that privacy. There has to be a reasonable basis for my doing so. My suspicion that they may be smoking cigarettes doesn't give me the ability to go into that unit.
But it's in our lease.
It's your property.
It is my property, but it's subject to the rights of my tenants. And my tenants do have that right of privacy. It's their home. I mean, let's suppose they're in there engaging in legal activity, but it's activity that they don't necessarily want us to, so they're having sex, the couple's in there having sex.
You can't say
I mean, that's a
that.
legal activity under most
This is a
circumstances.
family show.
Okay, so what are they doing then?
I don't know.
Well, so our lease,
how would you like to have a
hold
landlord
on.
busted in?
Our lease, we charge $500 cleaning fee if you smoke. If you smoke cigarettes, if you smoke marijuana, if you burn incense, you're gonna pay any kind of smoke. If you burn your food, that's different, but you're gonna get hit with a $500 cleaning fee.
Really? Wow. No incense?
No, because that incense, if you're in a multi-unit building, that incense goes into the other apartments. You can smell it.
Well, it's not the smell.
Just
The
rotate.
cleaning fee isn't for the smell. The
But it's
cleaning fee
also
is with respect to
the
the
smoke.
soot that's left from burning incense or from the yellow staining on the walls from cigarette smoke. That's what that's for. It's for actual damage to the premises above ordinary wear and tear. And that's the other thing, as a landlord, our law is that, you know, you can't hit a tenant for a cleaning fee unless it's in the lease itself. You gotta have that in writing saying, okay, we're gonna charge you a non-refundable cleaning fee of X dollars at the end of the lease, or for, in this case, activity that was prohibited by the rules and regulations.
Okay, so let's talk Orange Peacock Gallery for a second. This is a multi-purpose show. We have an artist reception on Thursday from 4 to 6. So come on down, and it's Jeanette Woodard. She does glass work. She's got some really cool sushi dishes, a glass cactus,
She's bringing other stuff down.
and she's bringing some other really nice stuff down. So come on down to the Orange Peacock, which is in the first floor of the Jackson County Tower Building, 120 West Michigan Avenue, between 4 and 6 on Thursday. Houses that we need to get sold is 941 Bellevue, 74.9. It's a 3-bedroom, 2-bath, just shy of 1,200 square feet. Nice little house, easy house. 1913 Woodsum, 49.9. That's a 3-bedroom, 1.5-bath house, just shy of 900 square feet. The cool thing about that one is you feel like you're in the country even though you're in the city. And because there is no house next to it, and then you have Ellisharp Park right there. 468 Skyline Drive, that's 450,000. That's a great house. That's a very cool house. 3 bedrooms, 3.5 baths, 2,300 square feet. Has an amazing outbuilding and walkout basement. 805 Southwest Avenue, really cool Tudor, 154.9. That price has been reduced. Lookout Circle, great 2,000 square foot, 4-bedroom, 2.5-bath house for $159.9. And Virginia Court, access, really close access to Clark Lake, 1-bedroom, that's a cream puff, $161,000. Call me, 780-3800.